Hey there, fellow Portland landlords and property managers across Oregon. It's Mr. Portland Landlord here. And if you're like me, you're always keeping an eye on court decisions that could shake up how we run our rental businesses. Just last month, on March 5th, 2026, the New York Appellate Division, 3rd Department, dropped a unanimous bombshell in the case of People of the State of New York versus Commons West, LLC. They ruled that New York's law forcing landlords to accept Section 8 vouchers is facially unconstitutional because it compels private property owners into warrantless government searches. Now, before you think that's New York, not us, hold on. Oregon has had nearly identical source of income protections on the books since 2014 under ORS 659 A.421, and our local public housing authorities like Home Forward in Multnomah and Clackamas counties, or the Housing Authority of Washington County, run the same housing quality standards inspections tied to those housing assistance payment contracts. This ruling isn't binding here, but it is highly persuasive on a core constitutional issue. Private landlords shouldn't be forced to hand over full and free access to their units and records without a warrant. And right now, with spring lease renewals and policy reviews happening, it is the perfect time to talk about what this means for us in the Portland metro area and beyond. Let's break it down step by step, the way we do in our PAROA classes. Clear, practical, and with real-world Oregon examples so you can apply it tomorrow. First, a quick history of the New York case. Back in 2019, New York passed Executive Law Section 2965A1, banning source of income discrimination to boost Section 8 participation amid their housing crunch. The law defined source of income to include federal vouchers, effectively requiring landlords to accept them or face penalties. In 2020, 2 voucher-holding tenants in Ithaca complained that Commons West LLC and other local owners wouldn't rent to them because of their Section 8 status. The New York Attorney General filed suit, seeking injunctions, unit set-asides, monitoring, and fines. The landlords fought back, arguing the law unconstitutionally forced them into the federal Section 8 program. A lower court sided with the landlords in 2023, and the appellate panel just affirmed it unanimously. The state tried to defend the law, but the court wasn't buying it. The core arguments boiled down to this. Landlords said the law compels them to sign the federal HUP contract, which demands full and free access to the unit, common areas, equipment, and records for initial inspections, plus biennial or complaint-driven HQS checks. No warrant, no real consent. The state countered that inspections are voluntary, part of a closely regulated industry, or fixable via a new policy, allowing written objections and warrants in some counties. Landlords also noted the inspections have no real limits on frequency, scope, or timing. The judge's reasoning was crystal clear and unanimous. They declared the law facially unconstitutional under the Fourth Amendment because it indirectly compels warrantless searches. Citing key precedents, the court explained that when a statute effectively requires consent to inspections before you can even challenge them, pre-compliance review is meaningless. A landlord is required to sign the HUP contract, thereby expressly consenting to all searches before any opportunity to challenge a search would arise. They also shot down the state's fixes. The policy isn't statewide or binding on every PHA, and tenant consent doesn't save a facial challenge when the law itself authorizes the intrusion. The Attorney General is appealing to New York's highest court, so stay tuned. But for now, this is a big win for property rights. And now a couple shameless plugs. If the administrative burdens and inspection headaches of mandatory voucher programs have you rethinking your portfolio, Northwest Real Estate and Property Management specializes in full-service management and professional eviction processing here in the Portland Metro and Central Oregon. They handle the paperwork, compliance checks, and tenant issues so you don't have to, especially when fair housing rules feel like they're constantly evolving. Give them a call and let them take the stress off your plate. If you're not already a member of PAROA.org, now is the perfect time to join, especially with fair housing and source of income issues like this one making headlines. We provide landlord forms, monthly education, advocacy, and a supportive network of fellow owners so you're never navigating these challenges alone. So what does this mean for Oregon landlords right now? Our statute, ORS 659 A.421, explicitly prohibits refusing to rent or discriminating in terms because of source of income, which includes federal rent subsidies under 42 U.S.C. 1437F, that's Section 8, and any other housing assistance. No amendments since the last legislative tweaks. The law is current and unchanged as of the 2025 Oregon Revised Statutes edition. Local PHAs still require landlords who accept vouchers to sign HAP contracts and grant access for HQS inspections. Initially before move-in, and then periodically, usually annually or biennially. Home Forward in Multnomah County, for example, can be pretty prompt, but Washington County's PHA sometimes has longer wait times for inspections, which can delay your lease start. Refusing a qualified voucher applicant solely because of the voucher is still unlawful and can bring complaints to the Fair Housing Council of Oregon or civil penalties. The good news? The New York logic could absolutely support a future constitutional challenge here. It is not binding outside New York, but federal Fourth Amendment principles travel well. No identical Oregon appellate cases exist yet, but landlord groups nationwide, including ours, are watching. Don't be surprised if you see one of the large and well-funded organizations or management companies or rental unit investment firms in Oregon bring a case about this up through the Oregon court system. Voluntary participation still works great for many. Guaranteed rent from the PHA is nice. But forced participation treats your private property like a public utility. That's the core property rights issue. Is this realistic precedent for Oregon or other states? Absolutely persuasive on the constitutional point. Oregon courts have cited out-of-state decisions on similar housing issues before. If a Portland area landlord or group wants to test the waters, especially given county-level PHA differences in inspection burdens, this ruling gives strong ammunition. In the meantime, keep participating voluntarily where it makes financial sense, but know your rights. A smart, proactive step our state and local housing authority administrators could take right now would be to get ahead of any potential legal challenges by reaching out to stakeholders, landlords, property managers, and investors like myself, to explore ways to improve the program voluntarily. Instead of waiting for costly litigation, they could redesign elements of the Section 8 process to reduce administrative burdens and inspection intrusions, ultimately creating a program that landlords actually want to participate in. When participation is truly voluntary and mutually beneficial, everyone wins. Tenants get stable housing, and landlords gain reliable payments without feeling like their private property rights are being compromised. Hey, quick question for you in the comments. Have you ever run into inspection delays or administrative headaches with Section 8 vouchers here in Oregon? Drop your experiences below. I read every comment, and it helps the whole community. Let's get practical with best practices every Oregon landlord should follow today. First, screen voucher applicants exactly the same way you screen everyone else. Same credit score minimum, same criminal background check, same rental history standards. You can reject for valid non-source of income reasons, like insufficient verifiable income to cover the tenant portion, poor references, or past evictions, as long as you apply those rules uniformly and document everything. Second, keep detailed records, notes from every showing, application responses, and denial letters that clearly state the non-voucher reason. Third, know your PHA's specific rules. Home Forward's HQS checklist is public. Review it before you commit so there are no surprises. Fourth, if you're considering a challenge, document the inspection burden, photos, emails about delays, extra costs, and reach out to PAROA's members' only free landlord helpline for detailed assistance and guidance. Here is a quick checklist you can keep handy. What you must still do today under Oregon law. Consider all applicants without regard to voucher status, sign the HAP contract, and allow HQS access if you accept the tenant, and maintain habitability standards that meet or exceed PHA requirements. What could change if an Oregon court follows the New York logic? The ability to decline vouchers without fear of discrimination claims, no more compelled full and free access without a warrant, and stronger private property protections overall. Voluntary participation still has upsides, steady rent payments and a built-in tenant pool. But the administrative load and inspection intrusions are real. A little humor helps. Dealing with a surprise HQS inspector can feel like your mother-in-law showing up with a white glove test and a federal clipboard. Not fun, but manageable when you are prepared. Sometimes they will also note tenant problems or violations and actually help you enforce their rules. In Oregon, if a tenant is successfully evicted, they are supposed to lose their eligibility for Section 8 rent assistance. Bottom line, this New York ruling is a reminder that property rights matter, and voluntary programs work best for everyone. Keep monitoring the New York appeal. Watch for any Oregon legislative moves in the upcoming 2027 long session, and stay in touch with your PHA and PAROA. If questions pop up, reach out. We are here to help. Hey, if you are a Portland area landlord, come join the community over at www.paroa.org. We have got education, forums, networking, and we fight for your rights at the legislature. And for owners in the Portland Metro or Central Oregon looking for hassle-free management, check out the pros at www.nwrpm.com.